splitting assets or dividing what we call the marital estate in North Carolina is one of the most complicated and oftentimes, because it's complicated, contentious issues, or what lawyers may say ripe for litigation, meaning people tend to fight over money. In fact, it's one of the more common root causes of divorce in North Carolina, together with substance abuse or marital or abuse or things of that nature. So, you know, if the thing that caused the divorce is money, there's at least a decent chance that it's going to continue to cause problems as we march down the path of eventual divorce in Charlotte. So, how are assets divided? Well, the first thing is, and it's a great question because it's the process by which a family court judge must follow, or there is a process by which they must follow. And when you read these appellate opinions come out of the Court of Appeals, they will occasionally, you know, whack the hands of the family court judge and say, this is the procedure and protocol. So I'll answer the question the way the courts are required to do this. First thing is there's a determination of the assets and the nature of their assets. Now, there are words that the courts use. I'm using more simplistic language here. There are terms of art, but we want to determine what the assets are. And those assets could be marital assets. Those assets could be called separate property. Sometimes people call them individual property. And then there can be something relating to the changes or up and down values of some of those assets. So if you have a 401k and the market zooms during a period of separation, who gets that change up or down? Same thing with a house. Maybe the house value drops or maybe increases. So there are terms of art for each of these, but the first thing we do is figure out what's what and who owns what. Is there a house that is owned by the marriage? Are there cars that are owned by the marriage? Are there individual or separate property? Maybe you received a gift as part of a will of a family heirloom, a watch or a ring or something like that. And there has to be determination, was that made part of the marital estate? Was it an asset that was given to the marriage? We call that a marital estate. Or was it meant and purposely kept separate? Is it separate property? So once we do that, then the question becomes evaluation of things. So if something's deemed separate property, you don't have to worry about selling it. It's not subject to equitable distribution. It's not subject to splitting it up. And that's what the process is called, equitable distribution. And if it's separate property, you keep it. You don't sell it. If it's a marital property or if it's one of the other type of properties where there's a change in value, then there can be a complex process of valuation. That may entail using a professional to get an appraisal or appraisals on a piece of real property, your house or your beach house. It may require you using the NADA, the National Auto Dealers Association or Kelly's Blue Book or whatever, to value vehicles. You may need to have an accountant take a look at things. We use forensic accountants all the time to value what a retirement account may be worth, or some kind of deferred compensation program or plan, or look at the whole marital estate. And then once we know those values, it's up to the parties to decide, can we agree on those values? And then if we can't, it's up to the court to either accept or reject the different valuations. You might understand that one appraisal may come in high, one appraisal may come in low. And so there are a lot of moving parts here. So the answer is, will I be, to the question is, will I be required to sell my car? Maybe. It may not have been your car to start with, or will I be required to give up my 401k? Again, it may not be just solely yours. It depends. There are a lot of different mechanisms in play and processes. So give us a ring, 704-342-4357. My name is Bill Powers, and I'm here to answer your questions.